Welcome to the Capitol Forum interview series. My name is David Blotner, and we are delighted to have Alan Grunes here with us today. As background, Alan is a shareholder at Brownstein Hyatt, which he joined after spending more than a decade at the Department of Justice Antitrust Division. At the Antitrust Division, Alan led merger and civil non-merger investigations in radio, television, and other industries. Alan currently serves as chair of the Antitrust Committee of the Bar Association of the District of Columbia and is on the advisory board of the American Antitrust Institute. Alan, thank you very much for being here today.
David, good to see you.
So we wanted to start talking about the merger guidelines. You worked at the division during one revision of the merger guidelines, and they've been revised since then in 2010. What do you think were the major changes that were made with the 2010 revisions?
Well, it's interesting. When I was looking at the AT&T T-Mobile merger, I went back and I looked at the new guidelines, and two things really struck me about them. One is they are better economics. They're more up-to-date economics. There's stuff that wasn't in the old guidelines that is in there. Mm-hmm. And, of course, that's because of the people who were in charge of them, right? You had some of the best people working on them. But the other thing is that they are more, at least in my mind, they're more consistent with what the legal standards actually are. So it's a combination of giving you better economics and more appropriate legal standard. So to give you an example of that, all right? The guidelines, 2010 guidelines now talk about the incipiency test specifically, which is the test for mergers that courts apply.
Right.
That wasn't there. The guidelines also say you don't have to prove every single possible little competitive effect down to a dollar in order to enjoin a merger, which is consistent with what the courts do. All right. They also, if you remember, as I'm sure you do, the old guidelines had a footnote talking about innovation.
Right.
And the new guidelines have a section on it, and innovation is obviously really important.
Right, at least in certain kinds of markets. So what do you think? I mean, it's interesting that you say that you think that they're closer to the legal standards that the courts use, because traditionally the courts have always required the Department of Justice or the Federal Trade Commission to define a relevant product market, and the new guidelines seem to not be so concerned about what the actual relevant product market is.
Well, I mean, for sure they've backed away from making that the starting point for all merger analysis. They don't displace what the courts do. They don't change the standards. The courts still require proof of market, proof of product market, geographic market. They don't change that. But what they do is move the inquiry away from that, so it's less formalistic.
Right.
I think that was one of the criticisms of the old guidelines, is that they were too formalistic, and they probably were.
So do you think the division should move away from defining relevant product markets in the cases that they bring?
As soon as the courts are okay with that concept, I say go ahead. So right now, it's still a legal requirement, and so it's fine to feature something else, but you still, I think, are going to have to define the markets in a complaint.
So, how would you go about? I mean, how do you think the agency should go about trying to push the courts or move the courts to adopt the guidelines analysis as the standard and move away from, as you say, the more formalistic kinds of ways that the courts have tried to approach these cases?
Well, I think the same way that the agencies have done it in the past, which is as you litigate a case, you incorporate the guidelines into the analysis, and the courts gradually then incorporate the guidelines into their analysis. So although the guidelines aren't law, they end up being talked about in decisions. I think that happened in the H&R Block case.
Yeah. It's one of the criticisms of the guidelines, at least from the people at the Department of Justice, who have to litigate these cases is that the guidelines give too many opportunities for defense counsel to pick apart the department's cases because the guidelines allow for all kinds of different analyses and effects, and it's hard to sort of figure out what's the correct one to be using. Do you think that's a problem with the new guidelines?
Well, I've heard actually the opposite side of that asserted, which is companies are not happy that the guidelines seem to be so flexible, and they don't like the fact that the guidelines seem to be open to a bunch of different approaches depending on the matter. And companies say that decreases certainty, right? And part of the idea of the guidelines is to help companies know more or less what the line is.
Right. And so if the guidelines are more flexible, then obviously companies are left in the dark about exactly what analysis is going to be applied to their particular deal.
Well, I don't believe that, and I don't think you believe that, given the fact that for most deals it's pretty clear where there's no problem. It's only when you've got problematic deals that you then have to do the further analysis. And when you do the further analysis, hopefully you've got good antitrust counsel who understand the way the agencies work, right?
Right. So let me talk a little bit about some of the cases that the division has brought since the new guidelines, because I think it's been sort of interesting to see the way the division has tried to fashion these cases. There have been, you mentioned AT&T and H&R Block, and recently the AB Inbev beer merger case. All of them in the complaint highlighted, to a great extent, internal company documents that talked about the competitor that they were acquiring. What do you think about the division using those kinds of documents to sort of focus the case and fashion their complaint?
I think it's a good thing. The division, it's certainly not new. The division did it in the case that I was involved in, involving the National Association of Realtors, where you're using the documents to make a point and to support what your overall proof is going to be and tell the story, right? So going back to the Realtors case, the claim was that internet-savvy realtors threatened the old business model, and there was a response by the association. The documents were brick-and-mortar people responding, and they were business documents or emails or whatever, which suggested that there was a basis for the complaint. In AT&T T-Mobile, there wasn't as much, as I recall, citation to the documents, and it was a little bit muffled. It wasn't quite as clear who who was writing them. There were a couple of quotes.
Right.
In the Inbev case, it's almost like chapter and verse. It's like, this executive said that, this executive said that, right? And it really sets the stage for what the division was trying to prove there, which, I think it was a somewhat complicated, it is a somewhat complicated case.
Right.
So they had to make it plausible and credible. Another case where the documents featured was the ebooks case.
Right, sure. I guess what I find, I'm just wondering, what I find interesting is that it's almost always the case that you can find documents where a company is talking about its competitors. That's not particularly surprising. I mean, that's what you would expect, is that companies are concerned about competition and they're aware of who their competitors are. When do you decide that those documents are more meaningful than just the normal kind of chatter that you would expect a company to be having about its competitors? Why focus on those kinds of documents as particularly meaningful in a merger case?
Well, I mean, it's a good question, and I think there is a risk of overplaying the occasional bad document or taking something out of context. But the flip side is, if you have good documentary support, if the division has good documentary support for a case, and it has multiple statements, it should use that, right?
So what's always interesting to me about the documents, and what I've found kind of interesting with the division's cases, focusing on them, is trying to think about the issue of do you always have to find those kinds of documents nowadays in order to bring a case? And when you do find those documents, does that always mean that you have a case?
I think the answer probably is you almost always have to find the documents. There may be 1 in 100 cases that you could actually bring without documents, but you better have a good reason for it. It's sort of like, forensics on television is convinced people that you got to have forensic evidence, and if you don't have it in a real trial, you better have an explanation. I think it's the same thing. I personally believe the division should, if appropriate and necessary, bring a case where there aren't documents. There may be good reasons why there aren't documents. The flip side is that if you do have good documents, and you should in most cases, the documents should feature in a case. I think judges are used to looking at documents. Judges want to know what the story is. There are always arguments about, do these documents mean what the government says they mean, or do they mean what the parties say they mean, right?
Right.
But trying to do a case just based on economic theory, unless you're in front of a judge who's also an economist, seems like a recipe for less than successful outcome.
I guess what I'm thinking of are cases where you have an argument being made that the absence of documents that focus on a particular competitor mean that that competitor is not significant enough, and therefore the merger shouldn't be a problem, because obviously if they were a significant competitor, you would find lots of documents focusing on them. And I was a little troubled when I heard that argument the first time, because that didn't seem to me to be the standard. And I wouldn't want the standard to be that you have to always find the documents in order to bring a merger case.
Yeah, no, I agree.
As far as the econometric evidence, how significant do you think that should be in the division's cases?
I think like the documents, it depends on the case.
Yeah.
So kind of flipping over to the sister agency that's looking at Office Depot, Office Max.
Right.
How closely those two companies compete and how important the internet is. Those are empirical questions. They're economic questions which will be answered, I think, through economic evidence. How are they pricing? Are they pricing based on superstores, or are they pricing based on other kinds of stores? Are they pricing based on the internet? I mean, that was, the FTC's Staples case from a number of years ago had everything, right?
Right.
It had the documents.
Right.
It had the econometrics. It had a receptive judge who actually toured the stores and kind of felt like these are different. Are you ever going to get all those elements? Well, it also had like great economists, great trial lawyers, everything, right? How often are you going to get that? That can't be the standard to bring a merger case.
Well, it's interesting that you raise Amazon in connection with the Office Depot, Office Max deal, because part of what the antitrust laws try to do and what the agencies try to do is predict the future. And in 1997, I think that's when the Staples case was decided. Amazon was not a big deal, and there's an argument that they're still not a big enough deal. But if you look forward, what do you do with a situation like that? If you're the agencies and you have to decide how we're going to predict the future with something like Amazon out there, even if they're not enough of a factor at the moment.
It's a really good question, and I think the answer is the division tends to look out a couple of years. It's not going to look out into the way distant future, and it's not going to just look at the status quo currently, and I think that's appropriate.
I wanted to switch away to a little bit different topic, a broader topic that goes more to sort of the reason why we have antitrust laws. There's been an ongoing debate, I think, ever since the Sherman Act was passed about what the goal of antitrust law ought to be. And different people have thought about it differently. They've phrased it in terms of consumer welfare, and that seems to be what the Supreme Court has said, but nobody really knows or has been able to agree, at least, on what that term means. What do you think the goals of the antitrust laws ought to be?
Oh boy, you want to make the question any broader than that?
Let's start there.
Okay, well, I mean, I'm sure you'd agree. The goals today are probably not the same goals as they were in 1890. Would you agree?
That would be
with
fair.
that? Okay, I mean, the sort of populist underpinnings to antitrust are pretty much out of the picture. I probably have been for quite a while now. I tend to see antitrust as at least in some sense, an alternative to regulation in the modern world, in the regulatory state world. Mm-hmm. And yes, it is primarily concerned with consumer welfare. What does consumer welfare mean? Well, I mean, I think about the economic loss, the sort of loss that society gets having to pay higher prices or get less or substitute other goods, kind of that basic economic idea of consumer welfare. Are there other values that are relevant? Yes, I think so. I've argued that in the past, right? I've argued in the marketplace of ideas context that something beyond simple profit and loss should apply. And I think the courts actually are not totally hostile to that at this point. But, you know, as a practical matter, I think we are in the consumer welfare world, and that's what the agencies are looking at. That's what the legal standard is now. I don't see it changing anytime soon. Do you? I mean, do you think choice is going to become, or
no? But
like
and it's interesting. I mean, the AB Inbev case that we talked about, they seem to be very focused there on being sure that beer prices didn't go up.
Right.
That seemed to be the main concern, and they're very sort of focused on what consumers are going to wind up paying for these products. But it doesn't always seem as if consumers and what they pay is the only goal that the antitrust laws are trying to protect.
Well, I think the for me the more interesting debate right now is the one involving innovation and the question of whether innovation is much more important than price to protect. People like Herb Hovenkamp have said, if you stifle innovation, you've done a lot more than get rid of price competition, and the harm's going to be bigger. Right. And I think right now we're in the kind of morphing stage where there's a lot of attention being paid to how antitrust should respond to innovation. There's arguments on both sides. Mm-hmm. But it is clearly, especially in the new economy and the tech economy, innovation is probably more important than price. It's a more important issue.
And in terms of protecting innovation, what's the standard that ought to be applied there? How do you figure out when it's appropriate for the agencies to intervene?
Well, so I wrote something on this in December, which I called the next big thing, and it essentially said, look at the Microsoft case, look at what the D.C. Circuit said in the Microsoft case, look at cases then like the National Association of Realtors case, which dealt with online brokerage. Look at the Comcast NBC consent decree, which dealt with online video distribution, kind of the new thing, right? These are all cases about the new thing, and I think if you look at those cases, you can see a fairly consistent approach to how antitrust can get involved in innovation.
Is it just a matter of trying to keep the market open, or should the agencies actually be actively sort of discouraging sort of the incumbents from being able to get into these new markets as well?
you know, I, I guess from being at the division too long, I have a hard time thinking about the division as a social engineer. So I really do think you take the case as it comes, as opposed to you try to use antitrust enforcement as a tool to limit what incumbents do. The innovation story tends to happen when you have kind of nascent, smaller competitors. Maybe not even the market is recognizing that they're competitors yet, but the incumbents recognize that these are the sorts of folks who could displace us. And that's the sort of antitrust intervention that I think is appropriate. It would be, there are arguments to go further than that, like Tim Wu argues that essentially you should use antitrust in a way, as you were suggesting earlier, to kind of curtail the behavior almost before it starts. But I think that's really hard for an antitrust agency to do. Yeah. So on this topic, though, one of the points I made in the article is that I think the division is way ahead of the FTC in practice, maybe not in theory, but in practice. And I think the reason for that is because the division actually had to litigate the Microsoft case and got a roadmap from the D.C. Circuit about what it needs to prove. And the FTC hasn't, to this point, gone through the crucible of litigation in new economy industries.
Mm-hmm. Let me ask you another question about sort of where you think the agencies should be applying antitrust law. There's been some discussion that if the antitrust laws had been applied to the financial industry in a more aggressive way, that we might have been able to avoid the financial meltdown, avoid the too big to fail kind of banks. Do you think that the antitrust laws can be used or should be used to restructure an industry in that way?
Well, I think I tend to agree with what I've seen that suggests the too big to fail problem was not a problem as a result of a lot of mergers that created the ultimate banks that had problems. So the problem was somewhere else outside of the antitrust area to begin with. Should there have been more enforcement? I don't know. But, Deb Garza, after she left the division, testified that in hindsight, and this was shortly after the financial meltdown, in hindsight, maybe they should have looked a little more carefully at bank mergers or done something like that. But I think that's about all the division could do. On the other hand, there's been arguments over the years that when you get to like a handful of businesses, like 4 big accounting firms,
right?
The failure of one of them could be really bad from a market standpoint, right? And so maybe you should be intervening a little earlier. Now, what does a little earlier mean? And if you're the unfortunate person who wants to merge and you're being told, sorry, we're really not worried about your merger, but you're worried about the next merger, so we're going to stop your merger. Would a federal judge buy that? What do you think?
No.
Okay, all right. But it's a problem. It's a real problem, and I think it's a real problem because we're in the kind of small numbers competition game right now.
Right. And there's a lot of industries that are consolidating down to, as you say, 4 major competitors, say, and is that enough? That's always the question. And I don't know, what do you think?
I guess the answer is, there may be some businesses where the failure of one of them could have systemic consequences. Accounting firms, maybe banks may be an example. Mm-hmm. There are other businesses where you may have 4 competitors, and if one of them goes out of business, it's like, all right, you got 3 competitors. All right, prices may go up a bit, but there's no other harm. So, maybe there's an argument for enhanced scrutiny. Maybe there's an argument for new legislation. I don't believe there's a magic number. I'm sure you don't, do you?
No.
Okay, so, there's no magic number of how many competitors is enough and how many is too few.
Let's just talk a little bit about the AB InBev case, because that's another example of a case the division has brought where the number of competitors that the division sort of alleged were going to be left after that deal was going to be, basically eliminating the third largest brewer. And the division took kind of a novel approach in that case. What did you think about the way the division sort of framed that case?
It's really unusual. The division kind of takes Modelo as a maverick firm, right? It's the Corona people, but it's not your typical maverick, which is the low price person who's disrupting everything. It's the high price maverick. So the complaint, states a theory. You read it, you say, well, there may be some plausibility, and this sounds right. But I got to say, kind of in the lead up to that case, when I was looking at the merger and talking to people about it, I said, where's the problem here? You got a Corona, which is a lot more expensive than, Bud Light or whatever. How many people actually substitute between those? Those kinds of questions. And it was actually your group, the Capital Forum, that for the first time that I saw kind of laid out a theory. And when I read it, I said, that's a plausible theory. That's something that somebody might allege. And I know they were working on it a lot, but kind of the nice thing, and congrats to the group on this, is that the theory was pretty darn close to what DOJ alleged. So it was obviously real deep look by the Capital Forum.
Well, Alan, want to thank you for coming today. It was a pleasure to talk with you, and hopefully we can do it again soon.
Pleasure is mine.
All right. Thanks.
Thanks.